Hi, everybody. Thank you for joining us today. We'll let everybody start coming in the room before we get started here. Welcome, welcome. Thank you for attending our DOT webinar from ArcPoint Labs. I'll give it a minute or two before we get started since everybody's just logging in. Welcome, welcome. Thank you for joining, everybody. Welcome to the ArcPoint webinar. Thank you for joining. We'll give it another minute or two as everybody gets in the room. Thank you again for attending. I see everybody's getting logged in. Thank you, thank you. It looks like our numbers are still climbing. I will just give it another minute before we get started here. Thanks everybody for logging in. Looks like we have over 100 people already here and it just now turned 1 o'clock Eastern. So excited to get things started here in a second for our DOT webinar from ArcPoint Labs. All right, I am going to go ahead and get started. My name is Jamie Welch. I am from ArcPoint Labs. I appreciate everybody getting ready to explore some great updates and information in the DOT world. We're actually going to be talking a lot about oral fluid testing today, and we know there's lots of changes happening here. So I'm excited about kicking this off and giving you guys some great information as we get started towards the back half of this year. Just as a friendly reminder, this webinar is certified for continuing ed credits, so we will give you certificates for attending 100% of our webinar. We have an hour this week, and we actually have a 2-part series, meaning in a week from today, we're going to have a second part focusing on the clearinghouse updates. Both of those, again, are credentialed for continuing ed credits, and we will be sending out certificates to the folks that attended by the end of the week for this week, and then we'll do again the same thing next week. So I'm going to go ahead and turn it over because this is a jam-packed hour to Leslie Prince. She is with Compliance Systems and our partner in crime for all DOT compliance things. So Leslie, I'll let you take it from here and I'll stop sharing my screen.
Thank you. Thanks, Jamie. Just so pleased that everyone is going to spend an hour with us today. And I was super excited when we reached out to Patrice Kelly, and she said that she would be willing to also spend an hour with us, instructing us regarding the oral fluid changes that are coming down the pike. As you read Patrice's bio when you registered, she is an attorney. She received her law degree from Georgetown and has since then just a storied career. But the thing that is most applicable today and the thing that is just such a feather in her cap is she was the longest serving director of the Office of Drug and Alcohol Policy and Compliance and the lead author in the newest update that include the oral fluid testing regulations. So you are learning from the expert who wrote the regulation, and when does that get to happen? So we're just so pleased to welcome Patrice to the ArcPoint webinar, and we'll turn it over over to her, and if you have questions as we go through, please put them in the question and answer, and then we will get to as many of them as we can at the end of our presentation today. And then if there's some we don't get to, then we'll have a form that you can fill out, and we'll respond back to you privately. So again, welcome, and thanks, Patrice, and I'll let you take it.
Thank you, Leslie, and hello, everyone. I really do want to thank ArcPoint Labs for hosting this. And Leslie, thank you so much for inviting me to join everyone today. And for everyone who's on this call, thank you so much for taking the time to learn more, because there certainly has been a lot of buzz about this and some uncertainty, but we're really in good shape to move full speed ahead. And presuming, there we go, that I can get this clicker to move. So this is my mandatory disclaimer. Back when I was serving as the director of the Office of Drug and Alcohol Policy and Compliance, I didn't need a disclaimer because I actually did speak for the Secretary of Transportation. However, I'm currently on a public-private partnership, a detail assignment with the National Drug and Alcohol Screening Association as their senior policy executive advisor. In this capacity, my views have not been subjected to review, clearance, or approval by DOT, and they do not necessarily represent the views of the department. But I can tell you, after being on this detail for almost a year and a half now, I've had the wonderful privilege to spend a lot of time with folks in industry, and many of you would know me from other contexts where I always make sure that I work my way around conferences and talk with everyone, because it's so important to know what really happens and what your concerns are, where the rubber hits the road. So the National Drug and Alcohol Screening Association was a really good fit for this detail assignment for me, because their mission is to advocate for safe and drug-free workplaces. And they do various forms of advocacy, not lobbying, but advocacy. And now they are the largest drug and alcohol testing association. When I first joined them a year and a half ago, there were about 2,000 members. Currently, they're up to 6,000 members. So NDASA really has become the go-to source for employers, service agents such as consortium third-party administrators, medical review officers, collectors, substance abuse professionals, et cetera. It's member-owned and member-driven. I've got on the screen their executive director's contact information, Joe McGuire. And every Wednesday, there's a town hall meeting at 2 p.m. Eastern Time. And I'm going to give you my email address now. And again, on the closing slide, it's Patrice, Patrice .Kelly, Kelly, at NDASA, NDASA.com. And I want you to feel free to email me if you would like to join for these completely free town hall webinar meetings on Wednesdays at 2 p.m. Eastern Time. It's my favorite hour of the week. It's where individuals, and I'm talking about usually about 150 to 175 people who are professionals like you are, get together and they talk about issues they're seeing. They talk about questions they have. It is not recorded, and you will not be held accountable if you admit that you're not in compliance and you need help. So it's a great forum to hear what other issues people are facing. So again, don't forget, if you want to attend this, it's free. You do not have to be a member, but I'm going to warn you ahead of time. Everyone I've suggested town hall to who has taken me up on that and contacted or joined in has wanted to become a member. So, but again, it's free, it's open, it's really, and NDASA wants to see people do the right thing. And that's one of the things I highly value about the organization too. With respect to oral fluid, we've been going around the country on a tour that we call Bringing Training Home to You. So we've been doing oral fluid training in various locations. I have provided the locations, and we are also providing these slides to you in a PDF format after the presentation. So I'm not going to read every word on every slide. We're just going to keep this moving and keep it interesting, I hope, for you and relevant. So I'm not big at reading outlines of presentation overviews because we're going to hit every topic. So oral fluid testing was approved by the Department of Health and Human Services. We'll call them HHS. And the reason why they're important in this process is because Congress requires them to be our scientists. They are the ones who certify the laboratories. They are the ones who determine what drugs we'll be testing for, what those cutoff levels are. They are the ones who oversee the laboratory process. Congress required us to follow HHS all the way back in 1991, and there's legislation out there that requires us to do that. So when HHS approved the oral fluid testing in 2019, made it effective in 2020, we thought that was great, and all these labs would come in and start getting certified, but they didn't, because HHS has about 200,000 tests per year, and DOT has about 7 million tests per year. So the economic driver for this was really the US Department of Transportation, and we knew that. We were able to get out the oral fluid final rule on May 2nd of last year. It became effective June 1st. I got that rule out as notice of proposed rulemaking and then brought it to final rule in about 13 months. And that's very unusual in the federal rulemaking process. It normally takes much longer. But again, because I was working on the Secretary's staff, my position was the first level of career people below the Secretary of Transportation. Secretary Buttigieg promised me that he would sign that out. And they actually didn't want me to go on this detail to NDASA until I finished writing the rule. So everything aligned perfectly for me to join NDASA on this 2-year detail last April. And then the Secretary kept with his word and got that rulemaking out for me. DOT issued 3 more rulemaking documents this summer. All of them came out on June 1st of 2024. They did not withdraw the oral fluid final rule. I've seen an article that has been spread around in the trade presses saying that this stops oral fluid testing. It does not. What happened this summer was DOT put out a technical amendment, which just made little nitnoid changes, typographical errors, things the Federal Register did not get correctly entered after we provided them with our draft. Then there was another document that they called the direct final rule, and that's the one I'll focus on briefly. In that, DOT said, we want to make just a couple of adjustments to some of the things in the collection process and the collection training, or collector training. But they said, if nobody objects, then that rule will become effective August 5th. Well, 16 parties filed comments, 13 of whom objected. So on August 1st, DOT withdrew this little, and truly by definition, it is non-significant, or in plain language, insignificant. But in the grand scheme of things, it was just to change a couple little nitnoids, but they did need public comment. I mean, they had typos in it, they had other problems with it logically. So please do not think that the oral fluid final rule has been withdrawn, slowed down, or stopped in any way. As I mentioned at the beginning, we are full speed ahead. So the final rule I discussed was technical amendments, and I wanted to give this to you in a slide format. So again, you can talk intelligently about it. If somebody says, hey, I thought that was withdrawn. No, it by all means was not withdrawn. What happened was this direct final rule that would have made changes to the collector provisions, as I said, was withdrawn on August 1st. It has no impact at all on the 2023 oral fluid final rule. That rule stands. There was a notice of proposed rulemaking that asked for public comment on the same subjects as the direct final rule. Again, little nitnoid provisions with respect to collection procedures, collector training, what have you. Those are still pending, but at this point in time have kind of become a bit overcome by events. And we'll talk more about that too. Because as I said, DOT has to use HHS certified laboratories. Remember, under the Omnibus Transportation Employee Testing Act, that's a very important piece to the whole oral fluid picture, is that we are tied to HHS. We're waiting for them to certify a primary lab and a separate secondary lab who would do the split testing for the positives and the adulterated specimens. HHS certification usually takes 3 to 6 months from the point an application is received. Well, guess what? Within the last month, 9 laboratories have submitted applications for HHS certification. So do the math. We're pretty close to seeing this move forward and click into place. But the question's going to be, are you ready for it? Oral fluid testing is authorized for all the DOT agencies. That's FAA, FMCSA, Federal Rails, Federal Transit. Pipelines and Coast Guard are also going to follow it, though they didn't need to change their regulations. But these modes listed on this slide also wanted to change their regulations. So I included that in our final rule that was published last May and effective June 1st. So in other words, DOT is all ready to go with this as soon as the labs are approved. It is as reliable as urine testing. And this was a very important point. As a matter of fact, this was one of the things that held up DOT moving forward with the final rule. We wanted to make sure with the NPRM, we wanted to make sure that the science was there. And we also helped HHS write their preamble to explain that the forensic defensibility was there, that it's scientifically as accurate as urine and forensically as defensible as urine. What's that mean for you in your role as a professional? Well, it means that your employees are not going to be subjected to a form of testing that doesn't meet the federal government's high standards. So, should you be challenged in a workers' comp hearing, pre-employment, unemployment, if you're questioned in grievances and arbitrations or court cases, you have language both in the HHS rule and in the DOT rule to support you. We reiterated the findings of HHS, and it's a good moment to take a quick pause here to explain in the rulemaking process for every regulation that's out there. There is a proposal and there is a preamble that goes with that. And then there's, most importantly, a final rule and the final rule preamble. And that's really where you want to focus. Preamble is the story. What's in the final rule? Why is it there? And what did the commenters say? In this oral fluid final rule, or actually to the notice of proposed rulemaking in oral fluid, we had 417 commenters. Some of those commenters had 17 pages single-spaced comments. Others had a paragraph or two. And regardless how long or short their responses were, I read every single one and made an attempt to address all of the relevant issues. And so preamble is the story. Why are things the way they are? And you can find all of those on the DOT webpage as well as the regulations at www.transportation.gov/ODAPC. Oscar, Delta, Alpha, Papa, Charlie. Okay, moving right along. All oral fluid testing is directly observed. That's a huge difference for us. It means that they're always going to be in front of the collector. And unlike urine, they're a lot less intrusive on the employee's privacy. So when we looked at it from a DOT standpoint, we decided that oral fluid testing is consistent with the constitutional balancing of an individual's right to privacy with the department's strong interest in preserving transportation safety by deterring illicit drug use. Will you see positives go up in number? Sure you will, because we're going to get rid of the cheaters by using oral fluid. If somebody's observed from when they first get together with the collector through the end of the test, it's going to be very difficult to introduce anything that could interfere with the test. And as of this time, HHS assures us there are no products that actually work for substituting or adulterating oral fluid. So as of this point in time, you're getting a test that is going to be very difficult to cheat. I'm also going to tell you my theory on this is build it and they will come. So once this is fully in play, the adulterant and substitution manufacturers out there are going to be working hard to see what they can come up with to beat these tests. And it's going to be a lot easier for all of us to stay on top of this because the collectors will be watching everything. Okay, the changes directly impacting employers in this final rule. Well, there's a lot of work to be done. You're going to need to update to explain whether you want oral fluid collections and under what circumstances, both in your policies and in your standing orders. And we're going to talk a lot about standing orders in the next 40 minutes or so. You also want to think about the fact that collective bargaining agreements may need to be updated because you're going to want to let your employees know what you're going to be requesting. And you don't have to tell them necessarily every detail, but you're certainly going to want to let them know that now you're also using oral fluid testing. And by the way, it's your choice as the employer. This is not an employee choice. This is not a collection site choice. This is your choice. Your consortium third party administrators or whoever administers your own program is going to be your expert in telling you what they recommend for each type of test. But ultimately, it's your decision. And guess what? With regard to policies and standing orders, you got less than 6 months to get ready. So you, not the employee, choose the collection methodology, oral fluid or urine, for your regular tests. So random, pre-employment, et cetera, as well as those problem collections like shy bladder, dry mouth, other tests that might require direct observed collection. You want to make sure you have business relationships with the oral fluid collectors and labs, whether you're doing that directly through your program or if you're doing it through your service agents like ArcPoint, like compliance systems. It's the best business practice to have a standing order in place. That's going to give people your instructions for each of your collection sites to do what kind of collection you want performed. If you don't have a standing order in place, you're going to need to talk to the collector before every single test. And why? Well, currently, when you send an employee in for a DOT regulated drug test, it's always going to be urine. I use the example of that's a vanilla cone. But after we have oral fluid testing fully deployed, the collection site won't know whether your employee is there for a vanilla cone or a chocolate cone. And if there's a problem during the collection process, is that going to become a swirl? Are you going to end up with an oral fluid collection and with a urine collection? Maybe if something starts as a shy bladder, it starts as urine, becomes a shy bladder, you'll switch to oral fluid. That may be your choice because the oral fluid period is going to run no longer than 1 hour versus the 3 hours for shy bladders. So again, you've got some decisions to make and you've got some wonderful experts to work with to help you make those decisions. Directly observed urine collections must no longer be performed for transgender and non-binary individuals once oral fluid testing is available. And let me just explain quickly what that means. So individuals who go in for a urine test right now are not observed. However, if it's somebody who is taking a return to duty test, a follow-up test, or if there was something that happened at the collection site or the laboratory, let's use the collection site example. Somebody walks in with a foaming blue urine. Well, once they present that to the collector and the collector realizes that a direct observed collection is necessary, the normal course of events under 49 CFR section 40.67 is the collector will say to the donor, due to the DOT's regulations, I'm going to need to do a directly observed collection and we'll have to use an observer of the same gender as you are. Since I'm a female, I will observe you. If the person who is the donor says, I'm actually not a female, I identify as male, currently, you're going to have to, the employer is going to be responsible for ensuring that a same gender observer is available. But the observer also needs to be informed that this person may or may not be anatomically the same as you and have the option for the observer to say, no, I don't want to observe this person providing urine. So see, it gets kind of tangly, and the best way to address that, we tried other things in this rulemaking, but those were rejected. So the best thing that we could think of then as an outgrowth of public comment was to say, whenever you have an individual who therefore says they're transgender or non-binary, meaning gender X, those individuals, if they have to undergo directly observed collection, must go immediately to an oral fluid collection. So oral fluid testing must be performed for all directly observed collections for transgender and non-binary individuals. And some people have said, well, that's not fair because shouldn't everybody have that? Well, first of all, the desired outcome is achieved because every oral fluid collection is a direct observation. And we don't have to worry about the civil rights of the donor or the observer. However, there still will be directly observed urine collections for everybody else, unless you, as the employer, choose oral fluid in every directly observed collection. And I'm going to ask you, why would you choose to proceed with urine? Okay, because now once something moves to a directly observed collection in urine, your costs of administering that test go way up because you've got to find somebody who's an observer. That's additional costs. And from what I understand, those can be triple, quadruple, 5 times the cost of a normal test. Why wouldn't you just move everything over to oral fluid for directly observed urine collections? Okay, so you could continue to have your other individual employees subjected to directly observed urine collections, but because you can, doesn't mean you should. And that's something I'd really like everybody to think about as you consider your options. Changes will need to be made if an employer's DOT policy states that urine is the only specimen authorized for drug testing. As a matter of fact, that is one of the largest or most frequent changes we made in that final rule, as I mentioned, for FTA, FMCSA, FAA, and FRA. A lot of them had the word urine in their regs. Is that in your policy? You may want to address that. You may want to state the testing events for which an oral fluid or urine collection will occur. It'd be a good idea to tell your employees they don't have the choice. This is your choice. You're paying for it. We did ask employers in the well, actually, we asked everybody in the public comments who should choose what type of testing goes on. And overwhelmingly, the response was the employers are paying for it. The employers know what their business necessities are. The employers need to choose. And the Department of Transportation agreed. So, also, when it comes to your employer's DOT policy, make sure you're following the requirements of the applicable DOT agency. That is FAA, FMCSA, Federal Rails, Federal Transit, Pipelines, or the United States Coast Guard. And that's why I know a lot of you are working with ArcPoint Labs and with compliance systems to make sure that you get those policies right and up to where they need to be in order to be compliant. Changes impacting current urine collectors as well as future oral fluid collectors. Because remember, urine and oral fluid collectors are all your agents. Ultimately, they are the agents of the employer. So the collector must ensure that the collector's telephone number provided on the CCF in step 1G connects directly to the collector and or the collector's supervisors, not a general call center. Okay, that's because employers need to be able to reach the actual collector. And I had personally experienced in my role in ODAPSI scenarios where the medical review officer or the employer couldn't reach a collector because they had to go through a general call center. And it took weeks. That resulted in canceled tests. Or for employers, you guys, if you're an employer and you handle FMCSA and you need to report things to the clearinghouse, you have how long? You have 3 days to report in a collection site refusal. How are you going to do that if you really don't have your questions answered by the collection site? What if your employee gives you one story that's not quite compatible with the quick and dirty notes you're getting from the collector? You need to be able to speak to the collector. And it's imperative to safety that we identify properly refusals and positives. So you and the MROs really do need to be able to contact collectors or their supervisors directly within 1 business day. So we got rid of the 1-800 call centers. The preamble reminds, remember, preamble being the story behind the reg. The preamble reminds employers to ensure the designated employer's representative name and phone number are on step 1 of the CCF. It's not a new requirement. It's been there since the year 2000. So 24 years now, I mean, sorry, 24 years now, we have had 40.40C2 say the DER's name and contact information needs to be on that CCF. Please make sure that you are available to the collection site 24/7. If your operations are 24/7, if there's a chance there'll be a post-accident test after hours, are you going to be able to be reached? Because something could happen, even if you have a standing order in place. If you have a standing order in place, it's likely you won't need to be reached, but what if the collector runs out of oral fluid collection devices? Because these devices have a cost and they have an expiration date. So a collector can't just override your standing order. They need to talk to you and say, listen, this is the time and the one and only time I'm not going to be able to do an oral fluid collection. Can you please work with me and can you send me an email to authorize me to do this right now? For employers, we remind you in the oral fluid final rule preamble to provide a list of qualified substance abuse professionals to both employees and applicants. What we're finding out there is, and you'll hear more about this next week about the clearinghouse data, but there are hundreds of thousands of people who are ending up in the FMCSA clearinghouse. And I would really say the vast majority of them have never been given information by the employer who used them or who interviewed them. Never been given that substance abuse professional information from those folks. That's a regulatory violation. And it's something that employers need to know about. How do you find qualified SAPs? Well, you can do it online. You can do it through business connections or other sources. And NDASA has resources for you. And it's okay to provide a list of qualified SAPs through a service who you hire. And right now I'm working on a document for NDASA that will also be given out to members on how they too can find substance abuse professionals. So if you're interested in NDASA membership, that's something that'll be on the horizon for you. Okay, pre-employment tests are different when it comes to refusals. And please listen carefully, because when I was speaking at one of the trucking associations in New York, a gentleman came up to me afterwards and he said, I have failed on this 20 times. I've put people in the clearinghouse who never should have been in the clearinghouse. Help me get them out. So a pre-employment drug test is something where you're asking a person to go for a test because you want them to work for you. However, you may have the best company on earth. People would be crazy not to work with you. However, sometimes people are gonna choose somebody else. They might have gotten a starting bonus or they might have been closer to home or what have you. If that employee does not show up at the collection site, or maybe they have a drug problem and they decide, hey, I don't even want to go into this field. I've changed my mind. As long as they leave before the device is unwrapped, in other words, before the collection's really underway, it's not a refusal on a pre-employment. They don't have an obligation to do this. So again, just keep that in mind. And the why not is the further down bullet here. And just remember that that's the truth. Do not put people who don't show up for pre-employment tests into clearinghouse. Do not deem them refusals. For the rest of you who are using 40.25 drug and alcohol background checks, don't report them out as a refusal for that either. So refusals, let's talk a little bit more about that too, because we also discussed that in the preamble to the final rule. Why? Because the clearinghouse is having all kinds of problems with this. Your service agents, your collectors, your CTPAs can tell you that something looks like a refusal, but it has always been the non-delegable duty of the employer to determine whether a refusal actually took place. And that's 49 CFR section 40.355, I as an igloo. The collector can tell the employer that something looks like it was a refusal. They can even say, hey, this was a refusal. That's not the final determination. The final determination is yours if you're an employer. In a pre-employment test, if the applicant doesn't show up or leaves the collection site before receiving a cup, then you know you don't even conduct that analysis. But I'm going to give you all a tip too. With employers, I know nobody loves confrontation unless you're a lawyer like me, but I really encourage you, if it's one of your regular employees, to contact them and make them explain to you why their refusal at the collection site happened. And then document what they say. You know why? Because after you start your disciplinary action against them, they're going to go on the internet and they're going to talk to the other jailhouse lawyers who've had refusals, and they're going to share tips on how they got off the hook. And if you're not in the know to begin with about what your employee says happened, then you may very well fall for the tricks that have worked for these other folks with their own employers. And of course, in dealing with collective bargaining unit employees, you want to remember Weingarten applies. So you don't want to call them in without a union rep. But for everybody else, again, call them in, have a talk, and see why that refusal occurred. Because you have to make a determination, and you should be able to prove to everybody you considered both sides. Service agents can provide advice and information to the employers regarding refusals to test, but the service agent's advice does not replace the judgment of the employer. When I sat in my chair in NDASA, I can't tell you how many people said, well, yes, I'm the employer of record, but I never would have called this a refusal. My collector made me do it, or my CTPA made me do it. No, it's not their responsibility. It's yours. So nobody made you do it. It is your responsibility. And we have entrusted you with that responsibility. It is profound. And we do expect employers to carry it out and not to delegate it. Now, DOT offers an employer handbook. And for those of you who haven't been on the DOT webpage, I'm going to reiterate it for you again, www.transportation.gov, ODAPSI, and you'll see a practice tip here. Be familiar with the DOT's employer handbook. And here's one of the things it shows you on pages 25 to 28. There's a chart, and it talks about what is the event that we're calling a refusal, who makes the determination, and DOT's instructions that'll help you with your decision. I'm showing you this page on page 26 because in the center top of the column, you'll see medical review officer is the one who calls this one. If a person fails to undergo a medical examination or evaluation, the MRO or employer has directed. And again, you would direct it because the MRO is telling you, I want this person to go in for the examination. They don't go. The MRO talks with you. The MRO declares that refusal. All the other circumstances I'm showing you here, you decide. Your MRO does not decide it. Your MRO does not enter it. This is your decision. And if it's not carried out properly, it could really result in somebody losing their job for the wrong reasons, and that could result in your liability. Okay, collecting oral fluid in-house with your own staff versus continuing to have professional collectors. This was a question that we framed for the public comments in the notice of proposed rulemaking. And overwhelmingly, employers told us they would not bring collections in-house. And here's why. It's the cost of training employees and then keeping them current. If you're only going to do one collection per year, that is something that is not really going to make it worthwhile to train your own folks. For those who commented, they didn't want the liability of having the human resources person who collected the specimen to also be the person who's involved in the disciplinary action for the decision not to hire or to terminate the employee. They'd need to get a contract with an oral fluid laboratory and make arrangements for a split lab so that they could have the split tested. They'd need a supply of oral fluid collection devices that are not expired. These things are going to expire in 1 to 2 years. And so, for a lot of employers, and it's a challenge for your service agents, to tell you the truth. It's going to be a challenge for the collection sites to not only purchase these, but to keep them current and to rotate their inventory. You know how you buy something and you forgot you had one in the cabinet already? and then you use the one that's newer, and then you realize when you go to use the other, it's expired. Same thing is going to happen with these devices. An employer said, I don't want to pay for that. I don't want to worry about that. So you want to think about, if you want to bring these collections in-house, do you have staff who have no working relationships with the donors and who would not be involved in disciplinary actions, who can perform the oral fluid collections? In other words, generally, it's not a good idea for HR folks to get involved in this. For employers, is it worth time and money to train your own personnel for an occasional collection? And what if an employee's called for a drug test and an alcohol test, for example, in a random or post-accident situation? How are you going to do that? Will you do one test in-house and then send the employee outside for an alcohol test? Think about it. Are you already doing the alcohol tests on site? If you are, it might be a viable option for you, but it's something that you need to consider. Really, does your company perform urine collections and breath alcohol testing in-house now? For a lot of companies who are huge, yeah, they do that. And so they're just going to add oral fluid to their repertoire. They know what the upsides are, the downsides are. They have a walling between the individuals who are doing the collections versus those who are taking HR actions and are providing HR advice. And if people want to switch over, if your company's saying, hey, we want to start thinking about doing our own oral fluid collections, I would strongly recommend that you all contact counsel about the liability issues, not as a threat, but just because it opens you up to a whole lot of liability that you've never faced before in the DOT regulated program. Again, remember, I'm not speaking for the DOT. I'm advising you as to my experience and the concerns that I read in the public comments, as well as talking to individuals, including attorneys, as I've traveled around the country teaching about this. So let's talk now about standing orders. Some like to call them employer protocols. Some like to call them instructions. I don't care if you call them Fred. Whatever you want to call them, every employer really needs to have a standing order. Is it a regulatory requirement? Nope. Can you run a drug testing program without one? No. A standing order is going to ensure the collector knows what kind of collection you want performed and under what circumstances. So it's your instructions to the collector. For those of you involved in transportation, you wouldn't pick up freight, you wouldn't pick up passengers without knowing what you were getting and without receiving instructions from the person who wants those individuals or the freight picked up. So a standing order also needs to cover what happens when a directly observed collection is needed. And remember, just because you can still do directly observed urine collections doesn't necessarily mean you should. You can still do them. They have not been removed from the regulation. They're only switched to oral fluid for individuals who are non-binary or transgender. But again, think about, what do you want your standing order to say about that? Have you started thinking about it? You'll need to instruct your collection sites directly or through a standing order as to what type of testing you want used and in what kind of situation. Even if you only want one methodology used, you need to be clear about that. You can use NDASA's model standing order format, develop your own, or sign one developed by your CTPA. I've put the citation here for where you can get NDASA's standing order. It is completely free, and I'm going to walk you through it right now. But it is free. You are welcome to use it. Okay, here's what the top half of the first page looks like. It's a 2-page document. We recommend that you print it out as a 2-sided document so that nothing gets lost at the collection site, but it's just too much information to put on one single side. So what it explains is this is going to be for this company, and this is a fillable PDF. You check for pre-employment, what do you want it to be? For random, what do you want it to be? Etc. The bottom half of the first page starts into the problem collections. What if you have a shy bladder arising during an initial urine collection? How do you want that to go? And remember, this is an area where I've been recommending that you seriously think about just having oral fluid for everybody. A directly observed collection, because the DER directs the collector to conduct one. Again, I'm sorry, shy bladder, let me correct that. Shy bladders are not directly observed. I apologize. But shy bladder is your 3-hour time block versus a dry mouth, which is a 1 hour. But what if you start with oral fluid and the person just physiologically can't produce that oral fluid? Do you want the collector to continue for an hour and see if the person can produce, or do you want them to switch to a urine collection? That's your choice. So it's the directly observed collections required under section 40.67, where the person has to work with an observer and show the observer that they're providing their urine body to bottle. That we're talking about. That's where it starts to get very expensive, introducing the observer. So this is the one here where I'm saying you don't have to say oral fluid, but why do you want to continue with urine? So again, more about the directly observed collections. This one, you'll notice there is no fillable PDF because this one is a directly observed collection for any reason and the donor identifies as transgender or non-binary. That's going to be an oral fluid. That's the one and only place DOT chose to mandate something. And then the final, this is the bottom half of the second page, put in the name of the DER, and the name of the authorizing official is the DER. They can sign it, date it, provide their phone number. That's really important. Again, it should match the collection form, but in any case, you want to make sure that everybody you communicate this to can reach you. And then putting in your email is a great idea. And then I put this little note in just because I'm a lawyer. And it gives you the right to revise the standing order. And if the collector comes across 2 copies with different dates, that's why it's so important that you date it, then the copy with the date later in time is the one that must be followed. Hot topic, marijuana rescheduling. So you may have heard in the press that marijuana, or if you have stayed in touch with Leslie or ArcPoint, perhaps they've informed you, but if marijuana is moved from its current Schedule 1 to Schedule 3, as was proposed in the notice of proposed rulemaking issued by the Attorney General, HHS is not going to certify labs for it anymore. The executive order issued by President Reagan back in 1986 allows HHS to certify laboratories and test for drugs that fall into Schedules 1 and 2 of the Controlled Substances Act. If marijuana is slid over to Schedule 3, which would make absolutely no sense for a whole lot of reasons, including the fact that nobody wants to go to pharmacies to get it. And as a matter of fact, the pro-marijuana people don't like the idea of rescheduling either, because that's really going to mess up states where they have recreational marijuana. And dispensaries are not pharmacies. So suffice it to say that going back to the idea that if it's moved over to Schedule 3, which nobody ever seriously considered, HHS is not going to be able to certify the labs. If there are no HHS certified labs, DOT must not test for it under the Omnibus Transportation Employee Testing Act of 1991. Remember, that's the statute that joined us to HHS. So in other words, DOT regulated testing for marijuana would immediately stop if it's moved to Schedule 3. If it's a Schedule 3 prescription drug, theoretically, all safety-sensitive employees can use it on duty and off duty until medical standards are developed for pilots and for others who are covered by medical standards, and until company policies are updated to address it. Have you considered updating your policy to state where your company stands on on-duty and off-duty use and what the employment repercussions are? And it's important for everybody to remember, there is not state in the United States of America that requires you to allow employees who are showing signs of impairment to continue to perform their job. Okay, so marijuana may be legal where you are, but you are not required to allow somebody to work in your workplace stumbling because they're drunk or because they're using drugs and actually showing you visible signs of impairment you're not required to continue to allow them to perform their work. So it's something to think about for your DOT and your non-DOT policies. So think about on-duty and off-duty use. And what are you going to do if it is rescheduled? And will you be able to pivot to address this immediately? Again, we're very hopeful that Schedule 2 will not come into, Schedule 3 will not come into play. And NDASA filed a request for a hearing. So that will further postpone the rulemaking. And NDASA filed 2 sets of comments on this. And the National Transportation Safety Board, a federal agency, also filed fabulous comments to explain to the Department of Justice why this should not happen. So I mentioned some of this on this slide right here. And now, as I promised, there's a little bit of time for questions. So Leslie, come on back.
Great,
Let me stop
thanks.
sharing.
All right, awesome. So we do have some great questions, and we'll answer the quick ones real first. So we'll get them knocked out. Some of them are a little bit more nuanced, and so we'll take a little bit more time to answer. So the first question is, how does, or what is the turnaround time of oral fluid compared to urine in the laboratory? So do you get the results back for oral fluid as quickly as you get the results back for urine?
That's a good question. We don't know yet. That'll be a great question to ask your laboratories when they come online. Remember, 9 of them are out there. And incidentally, for those 9, right now, they are all proposing to use the same device. We know what the device is at NDASA. We just haven't been authorized to announce it. That's something that's up to the device manufacturer. So everything's gearing up and ready to go. We are well prepared for this. And but right now, the turnaround times, it's going to be up to the individual laboratories and how well tooled up they are for it.
Great. The next question, kind of sort of addressed that. How does the collection of saliva get split? As far as
question,
the
actually. That's actually an excellent question, because currently there has not been a single device on the market until this one that's kind of a secret right now. There has not been a device in the market that meets the requirements that the Omnibus Transportation Employee Testing Act of 1991 has set for DOT. DOT has to have a device that has one specimen collected. Well, here, I like to do it this way. One specimen collected that gets subdivided in the presence of the donor. That can either be a neat collection device, which would look like an inverted Y, and the donor would expectorate into the top of it, and the oral fluid would go down into the chambers, or it would be a buffering device that collects 2 specimens at once, and again gets subdivided in the presence of the donor and sent to the lab in tubes that are properly sealed, just as you would with urine tubes. Think of that. So right now, there's not a device on the market except for this brand new one that has gone through the FDA clearance process and is ready to go.
Awesome.
So does that answer it? So that's how we
Think
split it,
so.
subdivided.
Yeah.
You cannot do consecutive, and you cannot do one in each side of the mouth. It has to be a single device subdivided.
Very good. Cool. Next question. If marijuana becomes a Schedule 3 substance, will the lab cease testing for CDL testing as well?
Yes.
Yep. So CDL test, so testing for your CDL drivers is DOT testing. And if marijuana does become a Schedule 3 drug, then the labs will not be able to do any DOT testing for marijuana. So pretty much.
If I can just add one thing
Sure.
to that, in NDASA's comments to the Attorney General, NDASA drafted up a model or an example of an executive order that the administration could use to modify the initial order set up by President Reagan that would expand HHS's authority to go beyond Schedules 1 and 2. That would be the exception. And actually, I have heard that that is under consideration at the top levels of the government, that the White House is aware of NDASA's comments. So if it moves to Schedule 3, but that executive order has been modified, then we've saved the drug testing for CDLs too. You know, if people are going to ask me to speculate on how likely it is it's going to be actually moved to Schedule 2, I'd say we're not going to see it in 2024 is my guess based on everything that's going on right now.
Awesome. All right, next question. Miranda Thomas has asked, who are the 9 labs that offer oral fluid testing? We don't know. So
there are none right now that offer it.
Right.
Remember,
they have submitted their
an application.
Right.
Right. But 0 offer it today. And that's
correct.
a fair clarification.
Yep. They have submitted, and we don't know who has submitted their packet. But again, just to underscore that nobody has been approved yet, so none of the labs are able to do it for DOT testing. Right. Sticking on kind of the same topic, when will oral fluid training be available in California?
Well, right now we did a lot on the West Coast. And then we started moving across the country too. We started on the West Coast. We started in Washington State. I'm not sure. There is some discussion about 2025, some training on the West Coast. But I don't have any dates available right now. What I can say is once the device is announced, NDASA is prepared to release the oral fluid collector training to those who have been trained as trainers, and also to post it on NDASA University so it can be taken online. And one more thing that I would suggest is for folks to check the NDASA web page at www.ndasa.com, because the regional trainings are listed there. And you can find the events, and you can see perhaps if we're not coming to California in a time frame that you'd like to have us there, there may be another larger city that you would like to visit and have your training done. We're getting ready to go to Boston, and we're getting ready to go to Washington, D.C. in the next 45 days. So I would say that's also, depending on how eager you are to get it done right now, that's the scoop.
Cool. Since all of the trainers are on the East Coast, maybe we'll go to Southern California in February.
Well, where it gets from here, it's just we finally made it to the East Coast. It's taken us so long to get here.
That's right. Absolutely. All right. Another question. From our understanding, oral fluid does not go back as far as urine does in the time of detection. Will this time of detection change?
You know what? When I wrote the NPRM, I went to all these different sources to try to put together a table that would give people the idea of the windows of detection. And there was a lot of controversy about that table. And so many different sources said either you didn't get it right, or please don't include it in the final rule. So I think it's fair to say that oral fluid will definitely detect more recent use. But for chronic users, it's going to detect use a little further back. And it's kind of the same thing with urine too. If somebody has only used marijuana once, then it's going to be a much shorter window of detection. For oral fluid, it's going to be not a tremendously long window of detection either for urine. But how many people are only using it once? So really for chronic users, you're still going to get a decent look back, but admittedly, it will not be a look back as long as urine. So that's something where folks like you, Leslie, and the folks at ArcPoint are going to be very valuable experts for their clients to be able to tell them, hey, listen, this is what I think makes sense with this type of testing. This is the look back you really want.
Great. All right. Next question. Can oral fluid be in place of urine for DOT? Are the oral fluid instant or sent to the lab?
Because of the Omnibus Transportation Employee Testing Act, all oral fluid has to be completely laboratory based. That's a good question. There are no instant tests allowed. And again, no labs are yet approved to do it, though 9 have applied.
Right. All right. So the next two questions are a little bit longer, so I'll try to take them in sections. So this first question is regarding oral fluid test reliability being equal to urine testing. Can you please go into a little more detail on what that means?
That means you're not going to get false positives or false negatives.
Very good. And then is it as accurate and consistent as urine testing?
Yes.
Okay. Every time there is a positive oral test, does that mean there is a direct positive result in urine and blood? So is there
There's a closer correlation between oral fluid and blood than oral fluid and
Right.
urine.
Right. And that just has to go back with the window of detection, probably.
Yeah.
Okay. And then you addressed this a bit when you said build it and they will come. Oral testing can't be cheated via some chemical additive from the user.
That is correct at this point in time.
At this point in time.
At this point in time. And one of the things about oral fluid testing is your body replenishes its oral fluid every 10 minutes, or in your mouth every 10 minutes. We produce between a half liter and 1.5 liters. So there's a lot of oral fluid happening. And so even if somebody takes something before they get to the collection site, there is a mandatory 10-minute waiting period. During that waiting period, the collector will fill out the paperwork, will have the person prepare for the oral fluid test. So it's going to be awfully hard to keep anything like that. And they'll do it, and the collector will do a visual inspection of the mouth cavities. So with all those things, it's going to be pretty hard to sneak something in, but never say never. That's what I kept telling HHS.
Cool. And so I will, if you have any more questions, we've got about 2 more minutes. Please go ahead and pop them into the question and answer, the Q&A. We've got 2 more to answer, and then I think that'll take us through our time. But if you have any more that we don't get to, we will send those out privately in an answer to you. And then also we will be sending out the slides at the end of the week when we send out the certificates and other follow-up information. We're also going to be sending out the standing order, NDASA standing order, so you'll get a copy of that. The last question, or next to last question, does the TPA report a refusal to FAA?
No, the employer would do that.
And then that also, is that with all FAA covered positions, or is that just
Good point.
certain ones?
Only pilots and mechanics.
Okay.
Pilots and mechanics must be reported by the employer to the FAA.
Cool. All right. With adulteration being a concern, is there a time limit between is there a time limit before the oral fluid test that the donor could not have food or drink beforehand? I think we just talked about that.
10 minutes. Yep.
Yeah, very good. And so just know that the oral fluid collection will actually probably take a little bit longer than just a regular urine collection. If you've got a good collector who's been doing it for 125 years, you can usually knock out, if it's an uneventful collection, you can usually knock that out in 6 or 7 minutes. Oral
Plus
fluid
the 10-minute
take
wait.
a little bit longer. Yep.
I was gonna say, probably, as you said, if you've got a good collector and an uneventful collection, probably talking 15 minutes. As opposed to 6 or 7 minutes.
Right. Cool. And last question, which we did address, is formal certification required to be an oral fluid collector?
Right. So it's covered under the DOT's regulation at 49 CFR section 40.35. That's everything that you need in there. As far as actual certification, you obtain that through National Drug and Alcohol Screening Association or whoever trains you. But remember, nobody is a DOT certified collector. DOT gives you the qualifications that you would need.
All right, good deal. Well, we are right on time almost. We're 2 minutes over, but we have answered all the questions that are in the question and answer and in the chat. Jamie, you want to take it home?
Yes, thank you so much. I know there's probably still questions that are going to come about. And as Leslie said, we will be emailing out a follow-up email by the end of the week. It'll be a wrap-up of the recording, the slides, the standing order. There is a little link in there as well that if you want to have a one-on-one consultation or there's still questions that you need answered, that is a way to get a hold of us. So hopefully you guys had a lot of, great insight and information. I appreciate both Leslie and Patrice for joining us today. Do not forget, if you are in charge of FMCSA employees and the clearinghouse changes that are coming about in November, or by November, I should say, we are doing a part 2 of this series next Tuesday at 1 p.m. Eastern as well. If you know anybody else that needs to register for it, you can go to register.arcpointlabs.com, or if you register for this one, you are automatically in for next one and stuff as well. Again, emails and certificates will be emailed by the end of the week. Thank you all for joining us. Happy Tuesday, and I'll talk to you guys soon. Thank you.
Thank you, everybody.
Thank you. Thank
Take
you.
care.